Okay, thank you for joining us today. I'm Steve, I'm head of legal of Pentalog, and today the webinar is about the general data protection regulations. So let's start. So just for you to notice, I will reply to the question at the end of the presentation. So you can write the question down, but I will reply to the question at the end of the presentation. So thank you, and now let's start. The evolution of personal data. The first law worldwide regarding data protection has been implemented in Germany in the state Hessen in 1970. And then the first general federal law in Germany has been enacted on 1977. And then following by France on 1978 with the Loi Informatique et Liberté. And then in 1995, we had the EU Directive 95/46/CE, and in 2000, we have the adoption of the safe harbor between the US and the European Union, the European community for the transfer of data between those two places. And at the same year, we have the proclamation of the EU Charter of Fundamental Rights. So in that charter in Europe, we has recognized the data protection as a fundamental right. This is the same level as the freedom of speech, etc. And we have a long period of time where all the countries were implementing the EU directive by voting some national regulation. And after the year 2010, we started having those massive attacks on internet, and that have led to the reinforcement of national legislation regarding data protection. And shortly after, in 2014 or 13, we have the Snowden revelation about the mass surveillance program. That was a proof that all the data regulation we had in place in Europe or worldwide were really inefficient. And shortly after, we have the safe harbor has been declared invalid by the European Court of Justice. And then in April 2016, we have adopted the GDPR. So this huge regulation that we're going to talk today about. And the privacy shield has been adopted on 2016 as well. This is a new way for European and US. If you're a business located in the US, you can receive data from Europe. And if you're under the privacy shield, that means you're giving to those data the same level of protection that in the European Union. But just note that the privacy shield has been very criticized since it has been implemented, and maybe something will happen to that, we don't know yet. But just remember that next year, May 25th, 2018, entry into force of the GDPR. So the GDPR arrives in the specific context. Substantial increase in cross-border flows of personal data, the rapid technological development and globalization, and the fragmentation of national legislation on data protection. Because since 1995, all the countries have their own legislation. So it was very hard to have like something harmonized. It was incoherent sometimes within the European Union. So this is how the GDPR arrived in Europe. So the GDPR contains 173 recitals and 99 articles. It's a very huge document, but it gave us many good information about how we're going to process data from next year. So what is a personal data? This is why we're here today. So it's very important to remember, to recall what the personal data is. So personal data can be physical, genetic, mental, and economic data. It can be your picture, an ID, an IP address, your ID copy or ID number, your passport copy or your passport number. It can be the date and place of birth, your home address. It can be your cultural and social data, anything you have in your library card, for instance. It can be your social security number, your phone number, and the GDPR gives us a very strong definition of the GDPR that you can find on Article 4.1 on the document. So it's any information relating to an identified or identifiable natural person. And an identifiable person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, identification number, location data, etc. So what we're going to do today, we're going to see what is the aim and the objective of the GDPR. what is the scope of the GDPR, what are the main elements of the GDPR, and how to be compliant with the GDPR. So let's start. The aim and the objective in the GDPR. Just remember, the GDPR establishes the rules relating to the protection of natural persons with regard of processing of personal data and rules relating to the free movement of personal data. The GDPR protects fundamental rights and freedom of natural persons, and in particular, the right to the protection of personal data. Remember, the European Charter of Fundamental Rights, the protection of personal data is a fundamental right. The GDPR defines the free movement of personal data within the Union. And remember also that the GDPR will provide a margin of maneuver for member states to specify its rule, including the processing of special categories of personal data, such as sensitive data. The GDPR will have a direct effect in all member states. No need any transposition law, as we did in 95 with the European Directive. The GDPR will replace all national legislation of the EU member states, including sector-related regulation. And then the GDPR will allow the European Data Protection Board, established thus the GDPR, which we call the board, to issue guidance in some specific contexts and areas. What is the scope of the GDPR? When we talk about the scope, we usually talk about the territorial scope and the material scope. But let's start by the material scope. So the GDPR applies in some circumstances and doesn't apply in other circumstances. The GDPR doesn't apply in the course of an activity which falls outside of the scope of the Union law. That makes sense. And it doesn't apply in the course of an activity which falls within the scope of a common foreign security policy. The GDPR doesn't apply to a natural person in the course of purely personal or household activity, which means if I'm drafting a list of my guests on my birthday party, the GDPR doesn't apply to the list. The GDPR applies to the competent authority for the purpose of prevention, investigation, detection, prosecution of criminal offenses, etc. Anything regarding what's going on in Europe right now with all those attacks we have. So the GDPR applies to the processing of personal data, wholly or partly by automated means, and to the processing other than automated means of personal data which part of a filing system or are intended to form a part of a filing system. The GDPR applies to the processing of personal data by the Union institution bodies, offices, and agencies. Now let's talk about the territorial scope. I want to symbolize this as a border, and then European Union and out of European Union. So the GDPR applies to businesses who are processing personal data in the context of activity of management of a controller or processor in the Union, regardless, this is very important, regardless whether the processing takes place in the Union or not. The GDPR applies as well to non-EU businesses, if you're watching the EU concern, but under some condition, of course. If you are a non-EU businesses and you're processing personal data of data subject who are in the Union where the processing activities are related to the offering good of services or related to the monitoring of the behavior as far as the behavior will take place within the Union, the GDPR applies to you. And if you are a non-EU controller, you're not established in the Union, but in the place where member states law applies by virtue of public international law, and you're processing personal data of data subject who are in the EU, the GDPR applies to you. So now let's move further. If I want to sum up this first, this part, the GDPR applies. The GDPR is not restricted to specific sector activities. It's applied to all sector are concerned. Whether you're a small or large business, the GDPR applies the same way with few exceptions. Then, if you are an EU business, the GDPR plainly applies to you. It was already the case with the directive in 1995. And remember that if you are outside the EU, United States, UK after the completion of Brexit, China, India, Cameroon, as long as your business is offering goods and services in the EU or monitor the behavior of EU citizens, no matter if you have a presence in Europe, the GDPR applies to your business. This is what we call the extraterritorial application. And the two exceptions, just to recall you that, the exception, the processing without any relation to commercial or professional activity, and the other exception, a natural person in the course of purely personal or household activity. I was talking about the guests of a party, something like that. That doesn't apply to you. So after this, let's move to the next step. The main element of the GDPR. There are several elements in this GDPR. First, you have the data subject right. You have the new requirements and obligations for data controller or data processors. You have the data processing rule and principle of lawful consent. And we have the sanctions. So now let's talk about the data subject right. As a business, seriously, as a business, you really pay attention about the data subject right. If you know the subject, the data subject right, you will be able to respond to them. So that's why you should pay attention to this part as well. So data subject right are divided into 3 parts. First, information access to personal data. Secondly, the rectification and erasure. Thirdly, right to object and automated individual decision making. When we talk about information and access to personal data, yes, the data subject has the right to receive information where the personal data are collected from the data subject or where they are not obtained from the data subject. And the data subject has the right to access. It can come to you and ask you, what data do you have on me? Are they processed? Yes or no, etc. So you have to prepare yourself to receive the kind of request. Rectification and erasure, right to rectification. Remember, the data must be accurate. And the data subject has the right to make a rectification. So if he has changed the email address, he has a different name, it can come to you and ask you to rectify the data you have. And the right to be forgotten. This is the right to erasure, Article 17 of the GDPR. Yes, the data subject can go to the controller processor and ask him to delete all the data he has on him. But if you want to see the exception, check the Article 17. It's not like a general right to be forgotten. It's the right, but few exceptions. The right of restriction of processing. Yes, I can say, I want my data to be processed on this purpose and not on the other one. Right to object on individual decision making. Right to object. Yes, I can say, I don't want you to process my data. Yes, a data subject has a law to do that. And remember, for those all to the right to be able to respond. Right to object to automatic individual decision making, including profiling. So you have to anticipate that as well. So now let's talk about the new requirements and the new obligation for the data controller that I would call the controller and the data processor that we call the processor here. So let's recall the definition of GDPR. The controller means natural or legal person, public authority, which alone or jointly with other determines the purpose and means of the processing of personal data. Article 4.7 of the GDPR. And what is a processor? Means a natural or legal person, public authority, which processes personal data on behalf of the controller, on behalf. So the processor is on behalf of someone, which is the controller. So let's talk about the new requirement obligation for the controller. So the two next slides will be very intense. So I won't tell you about everything, but I will put everything on the slides. But I will talk about a few boxes. So really pay attention here. So the first thing is accountability. The controller shall be responsible and be able to demonstrate this compliance. That's what we call accountability, though. This is a general obligations. So responsibility. Have you implemented the technical and organizational measure to ensure that you will be able to demonstrate that you're performing the processing the data in accordance with the GDPR? That's what we call responsibility. Joint controller. We talk about the joint controller that we will say like controller is when two or more controllers jointly determine the purpose and the means of the processing. Yes, there must be by means of arrangement between them, maybe in contract, in compliance with the GDPR, and you have to designate a point of contact. Of course, if you are a joint controller, you're going to be jointly liable, or each joint controller is liable for the entirety of the damage, but the controller can prove that it's impossible and may even bring the processing against the other control, etc. Data protection by design and by default. This is a notion that a lot of people are talking about. This is not new. GDPR is taking it back. It's just putting it again, sorry. So the controller shall implement appropriate technical measure and organizational measure for ensuring that by default, when you have a project going on, that only personal data which are necessary for its specific purpose of the processing are processed. So be very transparent with your client, be very transparent with your process. Everything you're putting in place, be clear, be transparent. This is how we're going to demonstrate that you're complying with the GDPR. And the controller outside the EU, if you're watching this and you are out of the European Union and you are running businesses in Europe on many states, you must appoint a representative in one of the member states in which you're offering goods and services or you're monitoring EU residents. So, but remember, this is not necessary when your processing is occasional and in small scale and it doesn't involve sensitive personal data. So you have to appoint the processor. If you're the controller, appoint the processor. Make sure it's compliant with the GDPR. Put it in your contract you have with him. Put it in a contract. Record of processing activities. You check the Article 30, it gives you all the information you need to put on your record of processing activity. This is very important because the Data Protection Authority can request it at any time. So you should be able to provide that to the authority. Data security, of course, you must take the measure, technical, organizational measure to ensure the security of the data against breach, accidental data, etc., and lawful destruction, loss, alteration, etc. And you have to make an adherence to a code of conduct, something like that. You have to notify the breach to the Data Protection Authority within the 72 hours from the moment you become aware of that. Exception where there is no risk from harm to any harm to the subject, and you will have to notify the subject if there's a risk to affecting the personal data. And data protection impact assessment. Yes. Let's say you are in a project, you have to identify and reduce all the non-compliance risk. So you draft a document and you enumerating the risk you have and the way you can put in place in order to reduce them. So this is when you have a systematic and extensive activity, so such profiling, processing at large scale, and some sensitive data, etc. Check the Article 25 for that one. So now let's talk about the processor. Yes, we record how to appoint a processor. It needs to be compliant with the GDPR, of course. Remind the scope of the GDPR. Yes. So sometimes you can have a conflict between the controller instruction and the applicable law. What's going on? So you must immediately inform the controller. And you may wonder what happens if the controller instruction put you in breach of national law after EU. No response. For now, maybe we are going to have something later, but the GDPR is saying nothing about it. Appointment of sub-processor. Yes, sometimes you have to appoint some sub-processors, but they have to be compliant with the GDPR as well, so put it in the contract. Obligation of confidentiality is the same as the processor, as the controller. Processing under the authority of the controller or processor. So if you have access to data when you're processing, you should only process the data that you have been instructed by the controller. Otherwise, you're not there anymore. So you can do that only unless it's required to do by union or member state law. So non-compliance with controller instruction. Yes, if a processor infringes the GDPR, but determining the purpose and means of processing, what should we do? The processor shall consider to be a controller as part of that processing. Yeah. Record the processing activity, we talk about it. You have to collaborate with the supervisory authority and data protection. You have to notify the breach to the data protection authority. And appointment of data protection officer if processing of sensitive data at a large scale all your main activities imply processing of large volume or data regularly. So don't try to figure out what means large scale. Don't try to determine what means large volume or regularly. I talked to the French Data Protection Authority a few days ago. They told me it's highly recommended to have a DPO. Highly recommended. Highly recommended. Principle for transfer outside the EU. We're going to talk about it later. This is a really big focus on this subject today. And liability, of course, you can be liable. You can be brought directly from that subject against you. So you can be liable for infringement of the GDPR. So after this, let's move to our next slide. The consent, data processing principle. So there are 7 principles, not you. You can find them on the directive, you can find them on the French law informatique et liberté. Lawfulness, fairness, and transparency, yes. You should have a legal basis before processing some data. It should be fair and transparent. Purpose of limitation, you have to limit what you're collecting to a specific purpose. Data minimization, only take what is necessary for the purpose. Accuracy, the data must be accurate. Storage limitation, you cannot store a data for like 100 years. Sometimes you have some legal obligation to store data at a specific time, like 3 years, 4 years, 5 years. And sometimes it's not in the law. Sometimes it's only regarding what you need to do with the data. So you have to get rid of them once the purpose has been reached. Integration confidentiality means that you have to put the security measures to keep the data in the total integrity and confidential. And accountability is the wall. What you have to demonstrate that to prove that you are compliant with the GDPR. So cumulative principle for fair processing. So what are the conditions for lawful processing? So if only one of the following conditions applies, the processing will be lawful. So let's go. The data subject has given his consent to the processing of his personal data for one specific purpose or for multiple specific purposes. The processing is necessary for the performance of a contract with the data subject or to take steps to prepare such a contract. The processing is necessary for compliance with a legal obligation. Let's say I'm an employee. I have like few employers here and I have to send some papers to the social security, etc. So I will have to process the data. I will have to collect data from my employee and send them to the authority. So this is a legal obligation I have. So there is a way to do otherwise. Processing necessary for the performance of a task carried out in the public interest or exercise of official authority based in controller. And processing is necessary for the purpose of legitimate interest of the data processor or controller. Now, do you know that regarding the consent, the controller must be able to demonstrate that he has obtained valid consent from the affected data subject. How? You have to know this. The consent is needed. In order to process personal data, you need a lawful consent. And the consent must be specific, which means like it has given the processing of personal data for one purpose. That's what we call principle of lawful consent that we talked about previously. What is a valid consent? The GDPR tells us that it's a freely given, specific, informed, unambiguous indication of data subject agreement to the processing of personal data relating to him. So remember that the consent must be a clear affirmative action by the data subject. Silence, petty boxes, inactivity does not constitute consent. If someone tells you, yes, he receives the email, but he doesn't reply, that means no, it's not a consent. It needs to be an affirmative action. A freely given consent is The consent should not provide a valid legal ground for processing the personal data in a specific case where there's a clear balance between the data subject and the controller. That means, in other words, and I can add that in the performance of a contract, including the performance of a service, is dependent on the consent despite such consents not is not freely given consent. It's not freely given consent. The data subject must be informed. Yes, it must be informed. Means that the nature of the processing should be transparent. Transparency. Remember that. Intelligible, easily accessible form by using clear and plain language, in particular for any information addressed specifically to a child. Yes, the data subject should be aware of the contact information of the controller. So you have to give him your contact information and the purpose of the processing, of course. Yes, the consent distinguishable from other matters in the declaration. Must be not inconsistent with the GDPR requirement. And yes, it shall be as easy to withdraw as to give consent. Yes, it's my right to withdraw the consent. I can do it at any time. So are we done with the consent? No, I insist on that thing because the consent is very, very important on the GDPR. So you should be very be aware of that. So the consent. What about sensible data? An explicit consent is required for those data. When the processing is based on consent, the controller should be able to demonstrate that the data subject has consented to the processing of his data. Presumption, yes, a consent will not be valid unless a separate consent are obtained for different processing activity. And there is a presumption that forced or omnibus consent mechanism will not be valid. Child consent. Processing of personal data of child is lawful where the child is at least 16. This is according to each country. Sometimes it can be above that, so be careful about it. Otherwise, the processing, you have to get the person who holds the parental responsibility of the child has to get his approval. So we're done with the consent guarantee. So gentle reminder on data transfer. So for all the people watching this, located out of the European Union, you are concerned about the data transfer. So I wanted to quickly explain you how this works. So it's very important for you to know about it. So you can be, you are out of European Union, and here this is European Union. So EU-based business, there is a general prohibition. Cross-border transfer is forbidden unless only if the transfer is made to an adequate jurisdiction or the data exporter has implemented lawful data transfer. What does it mean? What does it mean? First, transfer to a country that has received adequacy decision. Remember, almost more or less every 4 years, the Commission is reviewing the list of the country having the adequacy decision. Today, there are like 11 or 12 countries on the list. If you're not in the list, what's going on for you? Are you located in the United States? You should be registered under the Privacy Shield. That only means that you have the right to receive data from Europe. That doesn't mean you are compliant with the GDPR. Careful. Be very careful about it. Public sector regulated. If you're working with a public sector bodies, know that data transfer will be based on agreement between public authorities without the authorization of the Data Protection Authority. So you have to wait a bit for the practice to see how this works. The BCR, maybe you already know about it. This is very old. So internal rule adopted by multinational group companies define the policy about data protection and international transfer in the same corporate group. So if you have BCR implemented, that's very good. That means you can transfer data out of European Union thanks to the BCR. So if you want to see how to register as a BCR company, get close to the data protection authority of your country. So model contract, this is the model contract from the European Commission for transfer of personal data to third country. It's still in place. If you have it, you can transfer data out of European Union. And you have data protection authority clauses. I never seen one in my career, but it's one of them. And you have the code of conduct and certification. Remember that the code of conduct classification must be approved by the GDPR. So this is the way for you to transfer your data out of the EU under the GDPR. So what about the sanctions? Just remember, each member state shall provide one or more independent public authorities, data protection authority, to be responsible for monitoring the application of the GDPR. And what is the jurisdiction of a DPA? Is a national level. Exception, when you're talking about one-stop shop, it can have a possible impact on the processing occurring in other states. One-stop shop, if you're a multinational, that's for you. So that means you are in many countries, right? So you'll be allowed to have like a central point of contact, point of enforcement in one of the EU countries. So one data protection authority will be the supervisory authority. So it can be the one of a main establishment, or it can be the one of a single establishment of data controller processor in the EU. It can act as a lead SA. The DPA can regulate the business across all member states. The DPA has investigative power in case of breaches of GDPR, for instance. It can bring a legal proceeding when it's necessary. And data subjects have the right to lodge a complaint with a supervisory authority directly. So, in case of infringement, remember the supervisory authority shall ensure that the imposition of administrative fine, and those fines must be effective, proportionate, and dissuasive. How does it work? First, you have compensation. Means that any person can who has suffered material damage because of your breach, he should have the right to be compensated from you or the processor for the damage suffered. Exemption, if you can prove that you are not anyone responsible for the event giving the rise to the damage. Sanction from a member state penalty. Yes, member states shall lay down the rules on other penalty applicable to the infringement of the GDPR. In particular, for infringement, we are not subject to administrative fine. Yes, administrative fine. You heard about this probably, up to 10 million euro, or in the case of undertaking, up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher. Example, non-compliance with the obligation of the processor and controller, like child consent, processing of sensitive data, privacy by default by design, record of processing activities, securities, DPO, DPI, etc. Maximum administrative fine up to 20 million euro, or in the case of an undertaking, up to 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher. Example of breaches: non-compliance with the basic principle of data processing or the obtaining of consent, non-respect of the right of data subject, non-respect of the requirement for data transfer to a third country, non-compliance with the SA supervisory authority order, like restriction or suspension of data processing or flow, etc. How to be compliant, you may wonder. So, raise your personal awareness about the importance of the GDPR. Create a task force and assign a mission and a budget. Assess your current company situation and upon a DPO if applicable. Perform an audit. Get a data mapping. In the data mapping, you should be able to determine which service is concerned, who the data is related to, what type of data is processed, the source of the data, the legal basis, when and where the data has been collected, where is it stored. Know the data subject right and be prepared to receive some requests. Update your contract and other binding agreement with the clients and the suppliers. Adapt a strategy based on privacy by design by default for your project and services. Appoint a representative in France if your company is established outside the EU but implement data processing on EU territory. Establish procedures and be prepared for possible security breaches. Check your policy regarding data privacy and update your internal policy regarding data protection in compliance with the GDPR. And document your action regarding accountability and establish a close relation to your supervisory authority of the country in which your business is established. Make a phone call, send them an email if you need to know more. So this is what I should tell you about GDPR today. I really thank you for your presence, and now it's time for me to reply to your question. Thank you very much. So don't worry, the slide will be available online. You'll be able to download it and watch your video after. Thank you. So now I can see a few questions here. David, 2 questions. Can the last sentence of Recital 37 be seen as widening of the definition of growth of undertaking, or those still normal enterprises we have separate from the individual bank? David, can you take my I will give you my email, so I will reply to you by email because I think we're running out of time here. Yeah, you can get the slide. Can the role of data protection officer also be performed by company, legal person, or the, oh, okay, for this, yeah, David, yeah, okay, I will send you the response for those 3 questions. This is something people sometimes ask me, and up to today I can just reply you quickly. Yes, the thing is, the DPO should be someone. It can be a third party, someone within the company. It can be, yeah, it can be a natural person. Yeah, of course. But the thing is, it can be a legal person. This is not clearly established. I'm still trying to determine it with the French Data Protection Authority. But I will get back to you. I will give my email. It's going to be on the slides. So if you don't have any more questions, I will just thank you all for DPO can be in the IT department. The DPO, the thing is, the DPO should be someone who has some legal knowledges and some IT knowledges and some compliance knowledges. So it's pretty tricky as to establish who can be really a DPO. So each company has to figure out who's the best person can be a DPO. So find the right balance. Okay, thank you very much. So Peter, David, you're gonna have my email. Yeah, you will. No worry, you will get the slides. Cloud service provider. Okay, data controller or processor. Okay, for the cloud. If you are a processor controller, the processor, are you acting on behalf of someone, or just you're having just applied services? Because you can be jointly. There's a, let me go back to it. If you remember when I talk about it, you can be jointly liable for that. So I think for the cloud, it would be both, but I want to make sure about it. So and just before I leave, I just want to tell you something. Remember, the GDPR will come into force next year, right? But 179 recitals in 99 articles, that's huge. And many companies are behind the schedule. And it's not sure that everyone will be ready on the D-Day. And many people doesn't think that the first day you're going to have sanctions, etc. So we think that maybe this is what they said in the people are saying that at the beginning, probably the authority will be very comprehensive. They will try to give advices to company to be compliant. So we don't think that the first day you're going to have sanctions. So be in the steps, be on the path of the compliance, be there and make things, keep records of everything you're doing. If you make conference at your work, if you are drafting document about GDPR, keep them as a proof of what you're doing in order to be compliant. Okay, thank you, Michael. So I'm going to reply to some people here by email. My email is going to be at the end of the presentation, and it's going to be accessible by everyone who attended to the webinar. And I thank you very much for your attendance, and see you next time. So this is my email address. Just want to show you that before leaving, and we're done here. Okay. Thank you. Thank you all. Thank you all. Please put your email down here or send me an email whenever you can. I will reply to your question. Thank you very much. Bye-bye.